I'm a photographer. I live in Pittsburgh. I'm not an attorney. So anything we talk about here today is really a conversation. It's not advice. If you have an issue, how many of you think you might have a copyright issue, a big issue? There are plenty of attorneys that I could point you towards, or ASMP could point you towards. But what we're going to talk about today is really the issues sort of around copyright and how it impacts us as photographers and also as motion professionals. How many of you are doing video and motion clips these days as part of your practice? Okay. So very quickly, photography is morphing into a whole lot of interesting areas. But we're going to talk about copyright and how it impacts us. I apologize if the words are a little bit small. For those of you who, you can borrow my glasses if you need to read them. But the copyright is in the Constitution, and as it mentions here, it's in Article 1, Section 8, Clause 8. It's at the very top of the Constitution, and it has history going back to Queen Anne in England, around the time that printing presses were first becoming popular. So copyright has a long history because of the need of controlling copies. When you didn't have copiers or you didn't have printing presses, you didn't have to worry about copyright so much because somebody had to literally sit down and write by hand. But now we've moved into a whole new era of the internet. But I did want to read one section of this of the Constitution, which says to promote the progress of science and the useful arts. And I think that's important for us to remember, is that copyright is meant to promote knowledge. It's not just for making money. There is a point to copyright to encourage scientists and artists to create new work. And one of the ways that they did that was they put a limited time exclusivity period. Back in the early days of the Republic, that was 14 years. Copyright lasted 14 years. And we're going to talk a little bit more about how that's changed. But I think it's important to note that the idea is not just for artists to make a living, it also is to promote creativity and knowledge. So this is an area, there's a lot of mythology, there's a lot of misinformation and myth surrounding copyright. And one of them is that people want to copyright their ideas. And this is just not possible. If that were the case, there wouldn't be very many new ideas, because once an idea came up, nobody could, ever have a similar idea. So what we like to say here is that only tangible items, drawings, pictures, paintings, sculptures, things that have some quality to them, some tangible item, can hold the copyright underneath the Copyright Act. As an author of that work, you have exclusive rights. And I'd like to say here that copyright applies to everyone, not just to professionals. So my mom, who takes pictures with her camera or does little drawings or makes little paintings, she has full copyright protection the same as I do as a professional. And this is something that a lot of times professionals forget, that this law applies to everyone equally. But these are some of the exclusive rights you have as an author. And they include not only photography, but all sorts of things that can hold copyright. So you have the right to reproduce or copy, to create derivative works, which means if you make a photograph, you might want to make a painting of that, or you might want to have a sculpture created. If you're a writer, you might have a screenplay adapted from your writing. There's all sorts of different ways you can have a derivative work. The right to distribute. And this is a very, very important copyright that we have. We're going to talk more about distribution here in a few moments. And the right to perform your work, if you do work that can be performed, or if it's a photographic work, a right that can be displayed. So for us, it takes on a whole different meaning, the performance. However, if you're a motion photographer, you create motion pictures, your work is performed, not displayed. It's a slight different variation of the same thing. And also, this was, again, something that doesn't apply necessarily to photographers, but some of you may find yourself dabbling in audio works, and this is an important right that you would have. So like I said, the copyright goes back to the very beginning of the Republic. However, it's been revised a number of times. The most recent revision, the most recent overhaul of copyright was in 1976. And at that time, the goal was to bring copyright up to technological standards that were necessary. And for those of you who were around in 1976, do you remember what technological advances they were trying to come to terms with? Television and radio. So 1976 brought the Copyright Act up to television terms. But this is preceding the VCR, cable, the internet, Facebook. So the copyright law hasn't really been updated to really deal with those issues, which is why we have so much copyright litigation going on these days. In 1976, it's still required that your work be registered to receive the full protection of the law, and that still holds true today. And we'll talk a little bit more about what registration means. But one of the major differences that took place in 1976 was that the copyright fell to the artist. It no longer was in the hands of the commissioning party. So for those of us who work commercially, that was a big change. So for the first time, once this law became, once it became law in 1978, all of a sudden your commissioning clients now had to license the work from you. So for professional photographers, this was a change of business model, and one that I think we're still dealing with 30 some years later in terms of how we rectify that. There have been a couple of adjustments along the way. In 1989, the United States entered into the Berne Convention, which is an international treaty. And this aligned us with many of the other copyright laws around the world. At least, I would say, I think most of the civilized world has some sort of copyright laws, and this aligned us with all of those. One of the requirements that took place then was that the copyright notice was no longer required. And this was an important issue for photographers who, or all copyright owners, but specifically photographers, and how it relates to us is that if your work was published before 1989 and it was published without notice, you could have lost your copyright protection. So just that one simple error, or maybe it could have been on purpose, would have meant that your work would have gone immediately into the public domain or within a few years. So the requirement of no longer requiring notices, or the change that no longer required notices, was important, but it also had, I think, a downside, which we're going to talk about later under orphan works. So let's just keep that in mind when I bring it back up again. And just so you know, I put a little sign here. And what notice was, for those of you who aren't familiar, it was the little C with your name. Sometimes it had the date in there, and it had to be with all of the published works at that time. If you remember Sonny and Cher, he was elected senator in California, and he brought to Congress in 1998 the Sonny Bono Copyright Extension Act. This changed the time that copyright extended to the authors by 70 years past the death of the author. So when you die 70 years after, your work still remained in copyright. If the work was a corporate work, which means it was either, if you were an employee, like for example, we talked about the New York Times earlier, if you worked at the New York Times or you worked for a company, that would be 120 years or 95 years after publication, depending on which one was earlier. So this sort of changed, I think, for a lot of academics and librarians and cultural institutions, some concern. Because remember earlier we talked about how copyright's purpose was to promote knowledge and creativity. We've now extended the exclusivity period, which means that works aren't going into the public domain as quickly, which means that the knowledge isn't being shared. So there are some, and we're going to talk about this a little later, on the left, on we call the copyright left of things, who would like to see that change. They'd like to see the term smaller so that the work gets back into the public domain. So you're going to hear about that a lot. It's written about a lot, and it's one of the big sources of conversation these days. If you want information about works you've created and you're not sure what the term is because maybe that work was created before 1976 or possibly in the interim between 78 and 89, Cornell University has a wonderful resource that allows you to find out the term of the works you have. And you can actually literally type in Cornell plus copyright term and you'll find it. But this is the URL if you want to write it down. It's a really wonderful resource. So let's get to sort of some of the basic information. You create it, you own it. Except, there's always going to be an exception to the rule. If you, as the copyright owner, if you transfer that to someone else, and you can do that, it has to be in writing, but you can do that after the fact. If you've made a picture, or you've written a play, or you've created some copyrightable material, you can transfer ownership to somebody else. If you work under a work made for hire contract, which means that at least for the essence of that project or for that picture or whatever, if you've agreed before the picture was made that under the terms of work made for hire, the person you're working for owns it, as long as it qualifies, there are some qualifications for that, then you may not in fact own the work you create. So if you're we're going to cross into an area here that I think is important, and that is if you are creating motion, if you're creating motion pictures, if you're creating audiovisual materials, and you have hired a sound person and a director and a cameraman, all of those people on your production, you're essentially creating a multi-copyrightable piece. There's a lot of elements that are copyrightable on their own. So you may need to have those people sign a work made for hire agreement for you as the producer, if you're a producer, so that you all are working under one ownership of copyright. Otherwise, if you're creating all these different copyrightable pieces, each of them could be owned by somebody else, and you've created a joint ownership, which can be very, very complicated. So I mentioned this only because a few of you in the room shook your heads when you said you were creating motion. Motion is much different than photography in that it's not just a singular copyrightable piece. You're now creating multiple pieces that have copyright to them. So we can talk about this more if it interests you later in the Q&A, but those are some of the issues I wanted to bring up. And this especially relates to work made for hire. Yes, sir?
Really quick, if you do everything yourself making the movie or the video, would you have to individually copyright
No.
each thing?
No, that's one of the exceptions. The question was, if you're doing all of the jobs, you're capturing the audio, you're doing the directing. No, of course, you're the singular person. But if you have 5 or 6 people working for you, then you're going to need to make sure that there's an understanding of who owns what. Okay, so that's a good question. As far as questions go, let's try to maybe keep them either short or closer to the end so we can kind of like wrap them all up in together. But thank you for that. So there are some requirements for work made for hire that not all photographers fall under if you're working outside of the motion world. And so you need to kind of be familiar with them. Some of this information is available on the ASMP website. But I think in this case, what I'd like to do is kind of move on back to some of these exceptions, and we can always come back to work made for hire if we need to. The other exception is if you actually work for somebody else full time. And that means that they, in fact, are the copyright holder. So those are the 3 exceptions. Otherwise, if you're creating work, you own it. So therefore, if you have a copyrighted work, any person or business that wants to use that work in some way needs to get your permission. And in our world of professional photography, permission is a license. So I'm granting to you the rights to use the pictures. Of course, it could be an oral agreement, but as we all know, it's better to have a written document. In fact, I really encourage anytime you are giving someone the right to use your work, it should be in writing, just so there's no misunderstandings. And even among friends, I think it's good to have this in writing. It may even be important in your own family to have it in writing, because you don't want to have any concerns. So for us, licensing usually revolves around getting paid. So there's a fee paid for the use of the pictures. And again, I think it's important to have these things in writing and negotiated up front. So if someone's using your work without permission, it's essentially copyright infringement. If it violates, any of the exclusive rights that you have to photography. There are a couple exceptions to that. One of them is fair use, and you'll hear about that a lot. It's in the news a lot today. Unfortunately, fair use isn't necessarily fair. It's unfortunate that they chose that word, because a lot of people will interpret fair use as anything that they're doing is fair. It's easily to understand why this would be interpreted that way. However, most of the time it's not fair to me. So let's talk a little bit about what fair use is. Fair use is actually described in the copyright statute very specifically. And so I'm going to give you some examples of what might be considered fair use. And keep in mind that there are always going to be interpretations of that, because fair use is really a defense of infringement. That means that you can't claim fair use without actually infringing on a work. So if you infringe on the work and the courts decide that it's not fair, you're infringing. There's no gray area once that's been decided. Unfortunately, only a judge can really decide if it's fair or not. So what we have to do as photographers, we have to also be aware of some of the things that we do that we might consider to be fair use of someone else's copyright. And I like to use the golden rule. How would I like to be treated? But unfortunately, the Constitution doesn't always follow in that regard. So I'm going to show you some examples of how you can apply a fair use defense to infringement. And there are cases already in the courts that have decided some good examples that we can see. So we'll look at those. So I think you all understand why there needed to be an exemption for some of these things, because otherwise we wouldn't be able to have Saturday Night Live doing parody of a commercial. We wouldn't be able to have a critical review of a photograph or a book without having these exemptions included in the law. So here they are, parody, and this is all available either online or at asmp.org. So don't worry about writing them all down. Criticism, commentary, news reporting, education, scholarship, and research. Now, they look pretty vague to me, which is why there's been a lot of interpretation by the courts. We have a number of circuits in the U.S. federal court system, and they sometimes contradict each other on how they interpret this. So depending on which circuit you're in, you may find a slightly different variation. But let's talk, and it's hard to see these ones in red. Let's talk about the ones in red, though. Typically, a federal judge will use a four-part test. So this is the four-part test that the judges use. The purpose and the character of the use. One of the questions they would look at is it for a commercial exploitation, or is it in a nonprofit setting, educational purpose? What was the nature of the original work? And what was the intention of the artist there? They also look at how much of the work is being used in the secondary work. Is it a piece, or is it the work entirety? And then they also look at, and this is important for us professionals, is how it is impacting our market for that copyrightable work. So those are the four-part tests that the judges or the jury would use in a copyright infringement case claiming a fair use defense. They also ask these two questions, which I think are really interesting, and that is, did the unlicensed use, did it transform the original work? Did it turn it into something else? Did it add value? This is very important because in recent fair use cases, this has become the underlying issue. And we're going to look at a couple of those as an example. And then, of course, the question is the amount and nature of the material taken. A lot of times, audiences will ask me, well, how much of a work can I take and it be considered fair use? And there is no percentage. There is no exact amount. This is, again, interpreted by somebody who, in many cases, has no experience with art, has no experience with creativity, has no experience with the work that we do. And that's can be seen by some of the cases that come down and how they interpret them. Okay, so let's look at some pictures. I'm going to go back to the slide view for this, as long as I can remember my notes. So this was a case of an artist named Jeff Koons, very well-known artist, had a wonderful show in New York not that long ago. He had walked into a store and bought a postcard, which you see below, and the photographer's name was Rogers. I can't remember his first name right now, but anyway, he had taken this postcard and he sent it to the people who manufacture his sculptures, and he gave them direction on color and all that kind of stuff, but essentially created these sculptures at the top and sold them. I think there were 6 of them sold for hundreds of thousands of dollars, more or less. The copyright owner of the postcard challenged Jeff Koons, and the courts decided that it was not a fair use, that this was a derivative work, and that even though the photographer had not planned on making sculptures, it did interfere with his exclusive right to do so in the future. So even though the work, even though the photographer claimed it was a parody, or I'm sorry, Jeff Koons had said that it was a parody, and that by changing the color and all that sort of thing, that was transformative, they did not agree. They felt that this was not a fair use. Mr. Koons is well known in these court cases. This is another one. This is another one where he took a magazine photograph by a fashion photographer, Andrea Bloch, and created a piece below that includes a number of pieces, a montage, a collage, if you will, of photographs. And the courts decided in this case that it was a fair use because the amount was small. It's just the legs with the slippers. And as a whole, transformed the value of the original work. So in this case, he prevailed. He won as fair use. This series of pictures is in play right now. The Patrick Cariou is the photographer who did the black and white on the left, and Richard Prince, who's also not unfamiliar in this area of appropriation art, basically copied the pictures out of the book and added these paint and collage elements to them and sold them for a great deal of money at a New York gallery. Cariou brought a case against him for infringement. They claimed fair use. In the lower court, Cariou prevailed, and it was considered not a fair use. However, Prince and Gagosian Gallery have filed appeal, which is in appeal right now, and we don't know what the outcome will be. But what's at stake is transformation. Remember, I mentioned earlier that transformation is a big question in these cases, and there's some concern about, is there going to be a sort of an amount that's added to that? You know, how much transformation can one make building on a copyrighted work? It's something we won't know until the case comes out. It'll be interesting to see, mostly because there's a lot of other underlying court cases that have to do with transformation that don't give a clear picture on how this is going to be, you know, how this will play out. So it'll be interesting to see. So you can sort of stay tuned to the news with regard to this case. I also found some examples of fair use that I think we can relate to when it comes to news reporting. People will say, well, if news reporting is a fair use, then how can a newspaper photographer or how can a news journalist make a living, right? Wouldn't that be all fair use? Well, because there's trade practice We license journalism all the time. The issue really becomes when a news story is about a photograph, for instance. So in this case, these Abu Ghraib photos, it was a news case about the photographs, in addition to the underlying terrible things that were happening. As long as the story was about the photographs, they didn't need to be licensed. But if they were about the underlying story, then they would have been traditionally licensed by an agency. Now, this is not a great example because the Department of Defense declares these public domain. So it's kind of a null and void conversation, but it really is, I think, a good example of a photograph that becomes news. Another example is the Zapruder film. If you're talking about the Kennedy assassination and you're talking about that only, then the Zapruder film would need to be licensed. But if you're talking about the film itself, then in the course of critical, maybe you're talking about quality, or maybe you're talking about being at the right place at the right time, all these sorts of things, then this becomes more of a fair use argument. So I think those are two examples of that. Another area is when it comes into education. How many people in the room are teachers or speak regularly in schools? Okay. So the question becomes like, what are you allowed to use in the classroom and what would need to be licensed? And in most cases, if you're in the classroom and you're having a critical discussion about photography and you're showing, like, for example, my pictures or the pictures of Ansel Adams, it's usually in the context of a critical and educational viewpoint. On the other hand, if you were making a textbook about maybe even some of those same issues, you might need to get a license because those would traditionally be licensed for that use. So if you're in the classroom doing it like I am here today, doing this educational program, probably not necessarily need to be licensed, but I guess you could make an argument that in some cases it really depends on the situation. And that's going to happen a lot in a lot of these cases. I do mention this for documentary filmmakers because we have a fair amount of photographers moving into that space. And of course, when you start getting into film or into video, what starts to happen right away? Unlike the gentleman back here, we start to use pieces that aren't created by us. Maybe a photograph, maybe a song, maybe audio, all sorts of things. And one of the first things that comes up is, can I use these pictures? I'll give you an example. A friend of mine in Pittsburgh is working on a documentary about veterans. He wants to use pictures of the veterans. However, most of the pictures of the veterans aren't owned by the veterans. Can he use the pictures? He probably needs to go back to the person, the buddy that was in the army with them or whatever, to get permission. Sometimes they're not easily found, which brings us to a problem we're going to talk about in a few minutes called orphan works, which is a whole different ballgame. But I think it's useful here if you are a documentary filmmaker, if you're interested in that genre of work. There is the Center for Social Media at the American University. They have a lot of great information that can guide you down that path. There's a book, you can download this book, it's called Best Practices in Fair Use, and this is primarily for documentary filmmakers. It rarely intersects with photographers because we're creating usually singular works. But if you're starting to get into something where you're editing in other people's works, you're either going to be licensing that work or you're going to be looking for a fair use option. And it really depends on what you're doing on whether it falls into that category. So I just like to point this out as a resource. Another area if you're interested in this topic, Stanford University has copyright and fair use. They have a whole division dedicated to the study of this, and they sometimes are on the leading edge of trying to get courts to decide on these cases. I think as an artist, it's good to sort of know what's happening in our world, and this is one of the big topics in the art copyright world. So, which brings us to what I think many people refer to as the copyright war. And like I said, going back to Queen Anne, once the printing press was invented, it put the creators at odds with the copiers. And this has been ongoing, and it's going to continue as technology is always pushing ahead of what we create. So but especially let me ask you this question. How many people in the room create things that are copyrightable? Okay. How many people in the room infringe on copyright every day? That's it. That's true. It's almost impossible not to, And that's because up until the copier machine, or maybe the VCR, it was rare for the average person to actually infringe on copyright easily, because whatever you did to infringe almost took as much effort to create it originally, right? But all of a sudden, the copier machine, hey, I could take a whole book and I could copy the whole thing, and geez, I could make, if I was willing to stand there long enough, I probably could copy and make copies for my friends. So as it's become easier, we infringe regularly without maybe even intending to. So technology is sort of always leading the law. And I don't know if you've noticed lately, but Congress isn't really able to do much at anything, especially deal with an issue that the lobbying efforts on both sides are so heavy, and there's so much money involved in that who gets left behind? Most of us. Most of us, the artists, get left behind. So in the copyright war, if you can imagine for a second, on the right-hand side, on the copyright side, you have publishers, the movie studios, the big copyright holders on one side. And on the other side, you have librarians, and you have museum archivists, and you have exhibit curators who want to get information out. But you also have on that side now tech companies, Google, Facebook, Pinterest. Anybody ever heard of them? On the left, because they want to access that information as cheaply as possible, because that's how they make money on that information. And the thing is that we like free information. I like going to Google. I like seeing stuff. I like just sitting around and seeing what's on Wikipedia. So we are sort of stuck, the consumer as well as the artists are sort of stuck in the middle. And I believe that we're not getting a fair shake at this point. At ASMP, we try to be the voice of reason, and we try to be the voice for that artist in the middle. But we're 7,000 people. Do you know how many people actually regularly log into Google or to Facebook? I mean, it's a small sliver. So the cultural movements with regard to copyright are much, much different than what the legal community, Congress is willing to do, and sort of what we can do. But at the same time, I don't want you to feel powerless. I just want you to sort of become more of a student. Listen to what's happening, listen to the conversations, make up your own mind about what we can do as artists, and then try to work together with other artists. Join a group, let your voice be heard, and try to make a difference. Otherwise, none of this really matters, and we could just go out and take pictures in the sun. I'm all for that too. But I think this is what we have to deal with right now. We have a law on the books. It's been there forever. Let's try to make it work for us. And that's going to require all of you to not stand aside and be silent. Which brings us to one of the big battles in this copyright war, which is orphan works. And as Deborah mentioned earlier, she joined ASMP because we were in Washington, D.C. We were trying to make sure our voice was heard, the voice of photographers. And we were, I believe, a very open-minded. We understand that librarians want to be able to access material. And we understand that, for instance, the Holocaust Museum, which actually had a very good interest in this particular issue, which is that they had all of these troves of photographs and home movies and things that they wanted to exhibit and share and publish, but they didn't know how to identify the owners. So they can't do anything with them. It's sitting in a basement somewhere. So I think that we all recognize that this is an issue. My dad, he's doing genealogy. It's just great to try to figure out your past, and he's published these little books, maybe made 30 copies. But he wanted to include pictures of my great-grandparents and all of the relatives in between. Well, it's fine if I took your picture, or maybe, it's a family picture made by, Aunt Norma. But on the other hand, there are pictures in there made by studios. That work could be under copyright and probably is. Maybe it was never registered, but it may be. And the risk of using that work without getting permission could be very high. It could be $750 up to $150,000 per infringement. So you can see why my dad might be less willing to publish a picture, but also the Holocaust Museum might be less willing to do something. So we all know that there's a problem, and I think that AS&P, we're willing to kind of look at all of the issues. We're not as black and white as I think some people would like. But I think that at the same time, we don't want legislation to come through that takes away some of these rights that we need as professionals to continue working. So there has to be a balance, and it has to work for everyone. It can't just be one-sided. So you can see very quickly how. So an orphaned work is something that is probably underneath copyright protection, but you can't identify the owner, or if you can identify them, you can't find them. Businesses go out of business, people move, they don't have forward changing addresses. It's extremely problematic for companies that existed prior to the internet because nothing ever goes away in the internet. But if you were a business before that, you may have moved and not told anybody, and it may be hard to track you down. So anytime that you have a copyrighted work and you can't find the owner, or maybe there was no owner identified, and you remember a few slides ago I talked about notice. It used to be you had to have copyright notice. Richard Kelly took this picture. Well, all of a sudden, that's not required. All of a sudden, there are literally billions of pictures without notice. No way to track the owner. It's pretty crazy. So I actually think that attribution, being connected to your credit, even though it's not required by law, is probably one of the most important things we should be asking for if this OrphanWorks thing were to go through, because I think it's more important that we be connected to our work more than ever before. And there are some technological things that can be done. I'll show you a little bit later, but for right now, this is a big concern. For filmmakers, like I mentioned before, under the fair use thing, it can be a real problem. And filmmakers do something that photographers haven't really needed to do, which is clearances, which is if you have a film and you have all these different elements that aren't yours, aren't owned by you, you would have to get permissions from those people, and you have to log them in. And this is especially important when you go to register your copyright for the film, because you need to have exceptions for those pieces that aren't yours, okay? So it's called clearances. If you're interested, there's a number of great books on the market that talk about clearances for films. These are just some examples. If you're making a movie, some of the things you might have to clear. Trademarks, character names, location names, photographs that are in the background or artwork that's in the background. These are all things that a filmmaker is going to have to check. Doesn't it make filmmaking such a desirable career? Making films has a lot of responsibility to it. One of the things we can do as photographers, and you can do this right now today, and it's free, is to register your name with the PLUS registry. And what they do is it gives you a place that you can put your current information, your current phone number, your current address, website. This is important because if people are doing clearances or they're trying to find you, they may know that you took the picture but they can't find you. This is something that you can update, and I'm hoping will be kind of like a Rosetta Stone for finding people. It's called the PLUS Registry, plusregistry.org. And it is free. There is if you want to have a custom ID, you can pay extra for that, but I think the main registration part is free. The question was, if you use multiple names and you're going to register with the PLUS registry, how do you deal with that? And I believe it's all, the whole idea is that everything funnels down to one place. So if you use multiple names, they could still find you. Yes?
Enough just to repeat or elaborate a little bit on what PLUS registry is.
Sure. So the lady would like to know what the PLUS registry is. And let me back up a second, because I didn't really get into too much depth about it. PLUS was an organization created, it's called useplus.org. PLUS was created by the various members of the image community, including photographers, illustrators, stock agencies, advertising agencies, design firms, book publishers, anybody who uses images, pictures, photographs, drawings, as a way to come up with a common language for licensing. So that there wasn't a conflict that somebody uses one word but they mean something else. Is to come up with not only a common language, a glossary of use, but also to come up with a standardization worldwide of how a license is written. And this is important as we move into machine-readable technology, where computers need to read the license more than a person. So this was how it was first created, PLUS. They moved into the registry business with the idea of having an orphan works solution, and that is how they created the artist registry, which is called the PLUS registry, where artists create their name. We hope soon that registry will also include two other components. One is a licensing component, which means that as you license work, there would be licenses housed in this like silo of registries. So, and it would be attached by your name and your client's name. Why would you want that? Well, because licenses, if they're only in a file cabinet, nobody can find out, well, how long did we license this picture for? Or what is the use that we're allowed? Whereas if it's in a registry, it's all accessible. And then the third component would be an image registry, where photographers could have their images in this silo, and I'm a picture researcher in Norway, and I have a picture I'd like to use. I found it. I don't know who owns it. I would connect to the registry, and they would tell me that the woman in the front row, she is the owner, and I can contact her to get license for that. So it's an orphan works solution as well as a business solution. It's agnostic, meaning it's not an agency. They're not there to make a profit. They're there basically as a place that's reliable and that can house this information. Unfortunately, we're not to the second and or third step yet. We're just at the artist registry, which is a good first step. So and you can find out more about it by going to UsePlus or to the PLUS registry. And if some of you will probably be in town for the Photo Plus conference, the symposium, at the ASMP booth, usually to the left we have the Copyright Office, and we also have representatives of PLUS. So you can go in there and you can, if you didn't do it today, you can go there and actually sign in your name and create a registry right there and ask questions and things like that. Any other questions at the moment? So when the Copyright Term Extension Act went into effect, which, as we mentioned earlier, extended the copyright past 70 years beyond the death of the artist, there was a challenge to that by a professor at Stanford, Lawrence Lessig, and he lost. So he came back and they decided, well, how can we, as technology's moving forward, how can we allow creative people put their works out there without having to issue a license to everyone? So this concept was born, this idea called Creative Commons, which is the artist decides that they want to allow their work to be used in various ways. And there are 6 licenses under the Creative Commons. One of them is basically you can do anything you want as long as you give me credit. And the most restrictive is one that you can share my picture, but you can't make money from it. You can't use it commercially. And there's 5 in between, or 4 in between. I bring this up because a lot of times in our community of photographers, it's very misunderstood, and most people assume that it's not useful for professionals, and that's probably true. We make our money from licensing our work, so therefore giving it away to everybody would be kind of counterproductive. But on the other hand, there are some professionals who use Creative Commons as a marketing tool or a way of getting their story out and allowing people to either build on it or to do other things with it. What I like about Creative Commons is just that it's an intentional license. I decide to tell you how you can use my works. I'm in control. I think that as we move forward with technology, that's going to be a very important component, because right now, the way the copyright law is written, I am completely control of all of the all of the ways that my images can be used, and I have to issue a specific license, which can be very complicated if 1 billion people want to view my pictures or share my pictures. So this idea of an intentional license is pretty interesting. I think there's a lot of work that we can do as professionals to kind of figure out how to take what Creative Commons has done and sort of build on it, but we're not quite there yet. I think there's still a lot to be learned and a lot to be figured out. But what I do like about it is that the artist decides how their work is going to be used. Now, I like to show this as well. Oops, hold on one second. There is some information for filmmakers, specifically for filmmakers, and I bring this up because, as we talked earlier, as a filmmaker, you need different types of components. Some of those components might be Creative Commons licensed components, and there are very specific guidelines on how to use those materials. So you can go to creativecommons.org/filmmaker and find some of those resources. And this is what it looks like. It sort of tells you the rules of engagement, if you will. The other thing I like about these licenses is that they're icon-based. You can see that at the very top you have a little person. That's attribution. You can do whatever you want with the picture, but you have to give me credit. Every one of their licenses has attribution as a main component. You can see the very bottom, it's attribution, no commercial, and no derivatives, which means you can't make copies, you can't make sculptures, you can't do anything, but you can share it. So this could be very valuable, I guess, if you have an important story you want to get out. Yes?
Say you do number 2 or number 3 that says no commercial.
Mm-hmm.
Do you then have to copyright that image in addition to registering it with Creative Commons?
Okay, so the question was, if you're using Creative Commons and you're using no commercial licenses, do I need to register that work with the Copyright Office? Okay, I'd like to sort of reserve that for 1 second and just say this. Creative Commons is built on top of the copyright law. It's not adjacent to it, it's not in spite of, it's on top of. It's essentially the licensing component of copyright, except that it's a license that I'm telling the world I'm not reserving for myself. So if you don't follow the license that the copyright owner has given it, you're infringing, even if it's a Creative Commons. It's not a get out of jail free card for everything. So if you have, if the gentleman here that photographs in the railroad, right? If you had a attribution, no commercial, no derivatives, and somebody used your picture commercially and made paintings from them, it's still an infringement. Just because it's Creative Commons, they didn't follow the rules of the license. So it's just like any other license. So yes, your work, when you create your work, it is under copyright.
Right.
The only reason you need to register your work is to get added benefit. So yes, the answer is that there is an underlying copyright. This is just a particular type of license that you've given the work. Yes?
Suppose you do that, and then later on you change your mind, and
Yeah.
you have someone that you want to sell it to.
Well, it depends on which license you've chosen.
Third one.
Okay. Well, that one allows for commercial use. It just means that you haven't granted anybody else the commercial use. You can grant it to somebody else.
Oh, okay.
So the commercial use isn't limiting to you, it's limiting to everybody else. And that actually is an argument that some people within that community say is, look, I put my work out there, people see it, and then they come to me and they want to buy it. I'm not sure yet, because one of the biggest challenges to Creative Commons is that they haven't defined what no commercial means. They spent a lot of money to try to figure that out, and you can go to their website and read it. So it's inconclusive. But there are people, and you can search around and find information about people who actually find this as a business model. I haven't quite decided if it is or not, but it's not a. What I do like about it is that it's an intentional license, that the artist is deciding how the work is being used. And I think that rather than people infringing my work and then me deciding on whether I'm going to do something about it, if I want work to be shared, it should be, I should be not afraid to say, go ahead and use the pictures. There is a term that is used called innocent infringement. Okay. However, that doesn't mean you get out of jail for free. I think it can maybe sway a judge to reduce a penalty. But I say earlier, we're all infringers at some level. It just depends on whether or not the person we're infringing decides to sue. I think in these days we have there seems to be a lot more plasticity to that. And what I mean by everybody infringes, I don't mean we're infringing on a large scale. Most of us are doing it on our computers. You know, we see a web page and we print it out because we want to show somebody at the office, or, you know, I mean, we should have probably gotten permission to do that printing out, but we didn't. It's too hard. There's no marketplace to do that easily. Now, if you're a company and you do that, believe me, a couple of lawyers will be having phone calls. But for the individual, it's usually too small of a price to pay for me to print out a page, you know. So I think that we just have to be sensitive to the world at large, and we have to look at it through the same glass everybody else is looking through. And it's not always easy. I think it's a very challenging time to be both a copyright holder and a citizen. I think it's a very hard time to that, considering that in our pockets we carry a phone that can both not only take an image, but broadcast it within moments. I mean, can you imagine the power we have in our pockets? It's amazing. So every day we're testing the waters, if you will. I just want to show you this. This is the actual license underneath each Creative Commons icon. There's a different one. This one is for attribution non-commercial. So you can see this is and this is only part of it. It's actually like a huge document. So this is the stuff the lawyers read. And I just like to show, this is from today's Flickr. They have a Creative Commons was an early adopter, or Flickr was an early adopter of the Creative Commons model, so that users could let people know what their intention was. And this is only a partial shot, but it shows you, I think there's like something like 165 million pictures under Creative Commons on Flickr today, as of today. Okay, so I mentioned the Sonny Bono Act. The Sonny Bono Term Extension Act. Another important revision of the Copyright Act recently was the Digital Millennium Copyright Act. And this essentially allowed us to have, for good or for better or for worse, Web 2.0. Facebook wouldn't be possible, Google wouldn't be possible. All these are possible today because of something called a safe harbor. And that means that a company who creates a technology like Google is not liable for secondary infringement because they helped an infringement occur. So this provided a safe harbor for them. And in doing so, an artist like ourselves, you could issue a takedown notice to a website that's using your work and infringing on your work. You can issue a takedown notice, and the safe harbor company is required to take it down. So Google, if you reported to them on YouTube that somebody's using your video without permission, you could send them a takedown notice, and they would be obligated to take it down. There's a website called Plagiarism Today, and Jonathan Bailey, who runs this, has a wonderful stock letter. You have to follow a very specific language for a takedown notice. You can't just say, hey, they're using my picture illegally, take it down. I'm going to show you that letter here in a second. If you want, I can come back to this. So the letter sort of looks like this, and you just put in the title of the work and the address, the URL of the infringing work. So I like to just point people here. People ask me all the time, well, what do I do? Somebody has a picture of mine, they didn't get permission, I want them to take it down. I just want them to take it down. this is one of the avenues that you can take. There's also a wonderful book by Nancy Wolf, who's an attorney here in New York, and I can't remember if I have the title at the end of this or not, but in there she also has the language for a takedown notice that you can use. So these sites, we just talked about social media sites, wouldn't exist without the safe harbor. But one of the ways that they get around copyright is that they ask you to sign a terms of service. It's essentially a license, a global license, that by using their service, you're granting them certain rights. And also the people who are also members of that service also have certain rights. It's important that you know what you're signing. Of course, I'm sorry, what's your first name?
Liza.
Liza pointed out earlier, they keep on changing the rules. It's hard to keep up, hard to know. I have two websites you can check out. One of them is the Electric Frontier Foundation, EFF.org. They actually have a terms of service monitor page that will tell you when somebody's changed something you should know about. The second one is at ASMP, we have a resource about social media best practices. If you're going to post things into Facebook or Google Plus or YouTube or Vimeo, these are things you might want to know. Some of this is practical advice. You probably already know it. Think of it as it's like digital hygiene for photography and video. But what we did is we hired an attorney to read all of those terms of service and to sort of come up with some warnings that you should know if you're going to use them, and then also some guidelines. And the thing I think that we all know is that there is value in being in these places. It's just you have to be in these places smart. You have to know why you're there. You have to have a plan. And I think that if you do it with a wise approach, it can be mutual. I mean, I don't know a wedding photographer today that isn't on Facebook, because that's where you're going to get your clients. That's where they are. That's where the brides are. So you got to figure out how to play in that sandbox. And this is a good starting point to figuring that out. So these are some of the best practices. One is that even though it's not required, we encourage you to use a copyright notice. Use a watermark with your name. Use a watermark. Embed your copyright information in the metadata. Is everybody familiar with metadata and where to find it and how to use it? I will tell you, most social media sites strip it out. They take it out. Okay, now, I don't know why that hasn't been fought, because underneath the DMCA, one of the things you can't do is remove copyright notice, but they do. We've, at ASMP, have brought it up on numerous occasions to most of these companies. But I still think it's a good practice. If for no other reason than if you were to have an issue later on, you could sort of say to the judge, hey, look, I put the information in there. Somebody else has taken it out. So I did my part. Yes?
Can you just put a C next to your name?
I recommend it. It's not required.
No, but what I mean to say is you don't have to register somewhere
No.
that it's copyrighted?
No. Since 1976, you don't have to register the work. You do get extra benefits, which I'll talk about in a few moments. But the C is helpful, but not necessary, because it's not required by the Act anymore. Because in 1989, they removed that requirement. So, but I still suggest it, because I think it's still good to be attached to your work, like I said earlier. Yes?
I've seen ads for digital watermarking, like Digimark. Are you going to speak about that at all? I don't understand how that
Yeah, there are some technologies. Digimark is one of them. The question was, how do some of these technologies work with watermarking? Yes, they're still around. It's still a valuable service. I think the biggest challenge is there's maybe 5 or 6 different companies that have these sorts of technologies. None of them are standardized.
Okay.
So I think they are useful for tracking. I think the big challenge is that if you put your notice on a social media site, at least somebody can't say that they didn't know who you were. You know what I mean? If you have your watermark on there. Now, some photographers, myself included, I think that watermarking can look bad. It can take away from all of the visualness that we've added to our work. So it's a personal decision. This is just one of the practices that we recommend. And and whether your watermark is a little bug in the corner or it's a copyright across the whole thing, that's really up to you. I think it depends on your market. If you're a wedding photographer, you probably don't want to do that because you want to sell to that bride. You want her to see how great your pictures look. You might just want to have a studio logo. But if you're a stock photographer who's licensing work or you're selling prints, you might not want them to be able to just pull it off and have a print made. So you have to decide, again, sort of on your model, what you're doing, what the best practice would be. Yes, sir?
What is a bug?
A bug is just a small, you ever watch like on TV, they'll have a little transparent watermark in the corner. They call that a bug.
And what is that, like your logo? Or
Yeah, exactly. It could be a logo or
something that's really small.
Exactly. Something small that is obvious, but it's not, over the whole image. It's mostly used in video, which is why I included it here. Yeah.
If you register one of your photographs and you have variations of that, are they considered separate?
So-
Or are they under the same registration?
It's a good question. We can kind of deal with it a little bit later, but the quick answer is a picture that you have different variations. It depends on what you mean by variations. Most of the time, if the underlying source material is registered, you don't have to re-register it for other things. But depending on what that change is, if it's very transformative, you might want to. That's something an attorney who is familiar with your work could probably advise you on. I'm not really able to do that. Hold on one second. So at this website, which is an ASMP website, DP Best Flow, we actually explain how to embed, which means to add information, your name, your address, your phone number, to each of your digital photographs. And embedding is just a way of kind of, it happens on the file information about the picture that is invisible when you look at the picture, but you can find it with certain software. And this website will explain how to do that. It's called dpbestflow.org. And you want to go to best practices and you want to look under metadata, metadata, which is information about information. Hold on one second there. I'm going to show you this slide. Do you use a digital plan? Okay. Do you use Lightroom or Photoshop? Okay, Aperture. So in Aperture, you can do the same thing. I have two examples here of what metadata looks like. This is in Photoshop, and this is in the Get Info box underneath File. And this is this is the information about this particular picture. And you can create it as a template, which means you can batch it. You don't have to do it to every picture. I can do thousands of pictures at one time. So you want to learn how to do that in Aperture and apply it to all of your photographs. If you're in Lightroom, it looks like this. It's in the library panel in the lower right-hand corner. And again, it's all can be done to all of your pictures when you import them in or when you export them out. I mean, there's a lot of ways to add information about your pictures. And the most important thing is your name, your contact information. Again, many of these social media sites will strip that out, but I think it's a good practice for all of us to do whenever pictures leave our safe harbor at home. If you will. Just want to back up here. Another thing that you can do on some of these social media sites is if you are putting pictures out there, the real value in sharing is that you get connected to these pictures. If everybody likes your picture, that makes you feel good. It may not pay your rent. If you do that, make sure that people are tagging you because it connects you to that image, that tag. So, I do weddings occasionally, and if I post a wedding photo for someone, I always ask them to tag me, and that means I'm connected to that picture. So in addition to a watermark, it's valuable. There's another piece of software I think it's worth mentioning. It's if you do a lot of post work and you want to make sure that your licenses are embedded in your copyright information in your pictures, there's something called MetaMachine. META machine. It's very affordable. And one of the things I like about it is that you can kind of just drag a picture onto it and it copies the information onto the image. It's worth checking out if you're managing a lot of images in a stock library or something. It's just a nice piece of software. Some online tools that you might find useful, and you may know some of these already, but I thought I would at least point it out. TinEye is a search engine for images. You either upload it or put the URL in, and it will search its library. It spiders the web and tries to find other uses. In this case, a friend of mine had a book published, and he wanted to see if the book was if the pictures were showing up anywhere. And this happened to be showing up at I think it was a bookstore where his book was being sold. So that was good news. You know, it was an okay use. But you may find examples of your work that wasn't intended. They're infringements. So then you have to make the decision about what you're going to do about it, which we can talk about here in a second if you'd like. But I want to show you a couple of other tools. One is actually the Google Images tool, where you can, under Google Images, either put in a word or a text description, and it pulls up pictures that may have that text around it. You could also pull a website. Maybe you have a picture on a blog or a website, and it would find other images similar to that. We can always come back to these in a second. I just want to show you the 3 ways. The other way to do it is actually to upload. You click on the little camera, upload a little JPEG, and it will try to use that to find pictures. Okay? So what it's doing is it's searching its library of images for something that looks similar to what you have. I'll tell you 2 things. One is that this is a good tool for photographers, obviously. It's also a tool that researchers are using to sort of find you. So if your images are out there and available, you want to make sure that they can in fact find you. Because they can also, if you've never played around with Google Images, it's a very interesting tool. You can search by color. You can search by word. You can search by, I mean, there's all sorts of ways. And if you haven't done it, you should, if you're bored on a Sunday morning, put down your New York Times and pull up Google Images and just play and see what you discover, because it's a fascinating tool. And if you're a stock photographer and you're licensing your own work, you might want to figure out how to make your stuff more available so that people can find you, so you can license more images. This is a very powerful tool. But then we have to get into, how do we make money? It's all great and good if people can find you, but how do you turn it into money? There's a couple of ways out there. One is a very interesting product that PicScout, which is now a division of Getty Images, what they have done is create something called, what's it called? It's called the IRC. Basically, through the Google image search, you could find a picture, and if you had the browser add-on, and most picture editors are using this browser add-on, you can click on it and it will tell you where that picture is available for licensing. So this case, this is a picture of a cactus in the desert, and you can see that it says, oh, you can get this image at Dreamtime, which is a stock agency, and I go to their page, it clicks to that page, and oh, there's the picture, and I can buy a license. Pretty cool. Now, for those of us who aren't with Dreamtime and some of these other agencies, you can join PhotoShelter. PhotoShelter does have this as part of their plan. If you don't know anything about it, you can search and find out. But PhotoShelter allows an individual photographer to have licensable work available to the world, to be found. They have a wonderful series of books written about how to be found, how to use SEO, which is search engine optimization, how to build a blog to get your name out there. It does put a lot of work on your shoulders. It's not easy. But if you go about it in a thoughtful way, you can be found and you can be licensing your work, not just to somebody you know, but to somebody who you want to know, who has money.
What was that add-on called?
It's called Image. Oh, hold on one second. I knew you were going to ask me that. It's called the IRC PicScout Image Exchange. I tried to. You can click on some of these different things to go and get information. I happen to be listed in there, so when I pull up the page, it looks different than this. So I was trying to show you what it looked like, but this is the best way to do that. It's a pretty interesting technology. I have to say that I think that if that were connected to the PLUS registry, it would really change the way that this industry works. Really would change the way that we make money and who we interact with and how we're found. It's a very interesting time. I wish this were done already, completely done. But I think we're on the cusp of that. So there are pretty interesting ideas out there. Should I bother with copyright registration? So to get back to the question that we had here in the front row, when you click the shutter, when you do the little doodle drawing on your napkin at the restaurant, when you finish writing in your journal, that the work is copyrighted at that point. But there are some added benefits under the 1976 Act by registering. And when I say registering, it means you fill out a form. Have you ever filled out a tax form? Same type of process, government designed form. It takes about an hour and a half to explain it to you. It should only take about 10 minutes to fill out. And I do a workshop on how to fill out a copyright registration form. And the thing is, once you do it one time and you save the template, you can do it again and again and again very quickly. But a lot of photographers, and rightfully so, if you look at the software that it was built on, the Copyright Office, copyright.gov, you'll really understand that it was designed by a low bidder defense contractor with very little design sense. And as photographers, we're so visually inspired that if you follow your intuition, it'll be wrong. So what you want to do is, we have a wonderful tutorial on asmp.org/copyright that will walk you through page by page how to fill out the form. Put your address here, put your name here, because if you make a mistake on the form, somebody could throw it out. So what you want to do is you want to learn how to do it. It's very easy to register your work, and you can register unpublished groups of your work, which we're going to talk about here in a second. So I encourage you to at least look into it. If you have high-value work, you might want to register them in smaller groups or individually. This is something an attorney could advise you on, depending on the type of work you do. But it is definite. There is an added benefit we'll talk about in a second.
Oh, sorry, I'll let you continue. I had a question about groups.
Okay. Yep, we're going to talk about that right now. So this is what registration gives you. The first thing it gives you is evidence. You can't bring a case to federal court without registering the work. You have to have it registered before you can bring a case. It becomes principal evidence. It gives you the full benefit of the law, which means money, if you are infringed, because you can receive statutory damages and attorney's fees. The most important being the second, because it's federal court. There's a lot of discovery. They charge you a lot of money for this discovery. And lawsuits in this case can add up very quickly. You don't want to go down this road. As my grandmother used to say, don't make a federal case out of it. She was talking about copyright. So there are benefits to registration, because if the work is infringed after you've registered, then you get these benefits. I also think that registering is professional. And at ASMP, I created the initiative was to create registration counts, was to encourage professionals to register their work. And there's a number of reasons why I wanted to see that happen. But one of them is that I think it's the professional thing to do. It gives you the most leverage in a couple of situations. One of them is getting paid. Because when you license a work to somebody, most of our terms are 30 days, 60. Now, of course, who knows? But 30 days is, and my paperwork means 90 days to a client. But if they don't pay and they infringe the work, they don't have a license until they've paid, if your paperwork says that no license is transferred until I receive full payment. So if I registered the work before I delivered it to the client, and then they didn't pay me and they used the work, I might be able to use this as a real big stick in getting paid, because they don't want to have to go to federal court. It probably would be a lot easier and cheaper just to pay me. So it can be useful in that regard. So these are the two requirements. One, it has to be original. And number two is that you must be the author. You can't go out registering other people's work. You think it's humorous, but it actually happens. So these are the two things. And these are the two things that if you ever get into an infringement case, the lawyer will question. Is it original? And are you the author? Pretty basic things. And then there are 3 steps to registering your work. These are my favorite because they're federal favorites. You have to fill out the paperwork or online. You have to pay them. That's the most important part. Actually, it's the more important of the 3 because your registration doesn't come in place until you pay them. And then you have to send them a deposit. A deposit is a copy. So if you're registering 500 images, you could send in JPEGs or TIFFs. There's a number of different formats, PDFs, contact sheets. Remember those? Some people actually still register contact sheets. Or you're registering a book. Maybe you're copywriting a book, then you would have to send in a copy of the book. Okay. Depending on what you're registering, remember copyright law applies to everything including sculpture and painting and jewelry and all sorts of things. So copyright law doesn't just apply to photographers. So you have to think about it. Deposit requirements. Can you imagine taking your big sculpture down? You don't actually have to send in a sculpture. It doesn't fit through the internet very easily. But each different practice has different requirements. These are all available at the Copyright Office website. For photographers, we have pretty easy because it's easy for us to make small little JPEGs, 600 pixels wide. That's what I recommend. But it also means we're very prolific. A sculptor may make 12 pieces a year, and I make 1,200 pictures a day. Very different worlds. So the law applies to us all, but very differently. Okay. So here's where it gets kind of tricky right away, and that is that you have to segregate published works from unpublished works when you register them. And that is because the copyright statute is very specific on how it treats published things and unpublished things. It has to be treated this way because that's how it's written. I would like to see some of this rewritten, but that would require them kind of getting together and deciding that it's going to work out, and who knows. So I'd like to at least show you this, and that is what is publication, because it gets very confusing very quickly. This is actually from the Copyright Office, which is very clear. It's the distribution of copies or phonorecords of a work to the public by sale or other transfer of ownership or by rental, lease, or lending. If anybody in the back of the room can figure out what that is.
Put it up on Flickr.
And also at the very bottom, a public performance or display does not itself constitute publication. I know it when I see it. So here's what we've done at ASMP. We've created a best practices. I will tell you that we're very conservative, meaning that we err on the side of something being published when maybe a lawyer could argue it was unpublished. But we err on the side of published because the law benefits you if you register a work and it was published as unpublished, it'll be kicked out. So we err on the side that it was, even if it might not be published, we err on the side of published. However, these are actually pretty decent kind of guidelines. Public performance. For us, as photographers, that would be a public display, like an exhibition. If you're a filmmaker, that would be showing your movie somewhere. And we say that that's a maybe. It's hard to say. It depends on the situation. Your website, probably. In fact, yes, it is. Your blog, delivering your work to a client. I think that our advice is to register your work before you deliver it so that you take the maybe out of the equation. And then social media sites, of course, those are published. You must register before an infringement to have the full protection of copyright. This is important because I guess you can look at it this way, that if your work is unpublished, it's at lower risk, from being infringed. I mean, I have pictures that are unpublished in my studio in a box, and it's very unlikely that somebody's going to come in, open them up, take them out. But unfortunately, there are some parts of unpublished that people could have access to your images. So this is why it's important to register, I think, before you release your babies to the public at large. The one exception is that if you that you can register your work within 3 months of its first publication and still have the full protection of it. Let's say Liza here took a picture outside of on the street today, published it today, found out that somebody infringed on it on Friday. She could register it as published on Monday and still have the full protection even though it happened after the infringement because you have this 3-month window. That was in there because of news photography, because of things being, today, you can publish a picture and it can be infringed within seconds, right? So it's important that this be in there. It's very confusing sometimes for many people. Yeah.
If you have work that you're not initially publishing, but you're registering,
Yeah.
then later on you plan on publishing it,
Right.
and you have to register it again.
No, that's a very good question. So the question is, if I registered work as unpublished and then it gets published, do I have to register it again? And I would say, again, in most likelihood, no. There might be a small, exception to that an attorney might be able to tell you about, but no. Usually, once it's published or registered, it's registered. Now, of course, other derivative things may be registered for their purposes, like if it's in a book or, that might be copyrighted by the publisher of the book, but that doesn't interfere with your copyright. And hopefully you've actually licensed it and gotten paid, so even better. Yes?
I thought that when you were registering already published works that they had to be, it seems that it's changed, but they had to be, say you did some photos for a magazine, you have to publish those together. You couldn't just
Yep.
publish work for mixed, but it seems, I went on the website the other day and it sounded like they were saying you could publish photos from a calendar year, published photos
Yes.
within a but that's different than the way that
It is. It's being interpreted a little bit differently, and I think we're going to see. So the question has a lot to do with how you register published works, and there have been some interpretive changes to that, and I think we're going to see a more solid answer to that. I just had a conversation with some people at the Copyright Office about that the other day. And I think we're going to see something. I think in the last 10 years, there's been a lot of missed messages from the courts. So I think we're going to get some clarification on that. But these are the different ways you can register things for photographers. There is single unpublished, groups of unpublished, single published, groups of published in the same unit of publication. Talk about mouthful. And then also groups of published images in the same calendar year by the same artist. There are different deposit requirements for each of these categories. The easiest one for us is the single and the groups of unpublished, because the deposit requirement is simply uploading them on the ecosystem. That's the online system. You can upload your images there. Like I said, at the asmp.org site, we have a tutorial on registering groups of unpublished because we feel that's the best practice. But most of us in the room have published pictures too. So I'm working with my partner on creating a tutorial for photographers on registering published works because it comes up all the time in questions, but it's not done yet. So the only tutorial I have is the groups of unpublished because that's what we feel is the safest and the best practice. Yes, sir.
Yeah, is there a size limit on the number of images you can file in any?
It's a very good question. We were actually just dealing with this the other day. The answer right now is no. However, I feel that we probably should come up with a number because I get the question a lot. And there's a number of reasons for that. One of them is economic value. The other reason is that if you were to title each of the works, there's only a certain amount of characters that the titling field will take. So I think we need some clarification on this. We don't have it right now. The way it's written currently, it's unlimited, but I think that's a little bit crazy. I mean, 5,000, is that too many? Is 500 too few? I don't know. I have successfully registered I think about 1,500 at a time for $35, but I know people who register more and I know people who register less. The real issue for us as photographers is the economic value. $35 times all the pictures we make adds up quick. So we've been lobbying with the Copyright Office that there needs to be some clarification here, and that I'd like to see frequent copyright registers. Maybe a one-time a year fee to register as many times as I want. If I'm a frequent user, why can't I have a discount? So I don't know. I think your question is one that we get a lot, and there's not a lot of clarity on it. There are some opinions, but not necessarily. There's no absolutes right now.
Correct, so something like a high school class graduation picture.
Yep.
Might be one group, and a day shooting, another subject matter might be another.
Right. I have a very good friend who was a past president of ASMP. He registers every month. He registers whatever he did that month. Sometimes it might be a few pictures, and sometimes it might be thousands of pictures. That's his practice right now. But if we come up with a number and we say that this is what it should be, then we would have to amend our practices a bit. But I highly recommend, if you're interested in knowing more, is at asmp.org/copyright. There is a whole tutorial about the guidelines, how big to make the files, how to upload them, and some sort of technical things you need to know. Yes?
I have two more questions.
Sure.
Nowadays, we send CDs, I guess.
Yes.
Who's in charge of, at one point we won't be able to read the CDs anymore, I assume. So are we supposed
What's a CD? No.
So
Yeah.
are we supposed to send, say, years down the line, the same pictures to re-register them and to send whatever devices?
No, I believe the way that the statute is written or interpreted is your responsibility to keep track of what is registered under a particular registration. They put the burden on the artist. So you're going to need to know what you registered. You don't have to re-register.
Oh.
Because once they're registered, you get a certificate
Right.
stamped with the official stamp of the registrar. So you're good to go. You don't have to redo it again. And my advice is to migrate those images so they're not on those 8 tracks.
Absolutely, yeah.
Good. Yes, ma'am.
How long does it take?
Well, it's interesting. I was speaking with the Copyright Office the other day, and they're saying that they're actually turning stuff around within 6 weeks, especially if they're eco, which is pretty quick. It used to take 6 months, so it's happening pretty quickly. You can expedite it for $700 or something, but don't do that. I mean, very few of us need something that quickly unless,
And you said you get a certificate?
Yes.
So they send that to you in the mail?
Yep.
And suppose you've registered 100 images. Is there any
Yeah, it's funny.
connection between what you registered and the certificate?
That's what I was just saying, is that it's your responsibility to manage what that certificate goes to. Yes. So what I do is I have I actually have CDs of them, but I print out little lists, and I just staple it there.
Right, okay.
And it has a little icon. I can see what the picture looks like. If I have my glasses on, I can. This is important. This is copyright.gov. This is if you want to create your own registration account. And then this number, 877, if you can't read it, it's 877-476-0778. You call this number if you have a problem with registering, and they'll walk you through it. I've called this on a number of occasions, and they're very, very nice people. So, it's a good number to have. Sometimes you'll have a problem like filling out the form. They're very, very helpful people that answer. Unlike another government agency, this one actually is very nice, very nice. I can come back if you want this, but I just want to show you a couple of resources. So this is the ASMP website. /copyright takes you to some information there. And we are updating some of that right now. So there's some new things coming out soon that's, I think, relative to some of the questions we had here today. If you're interested in getting these slides, if it just helps jog your memory, I mean, there's not a lot of information there, but there's some. You can just send me an email. It's Kelly, K-E-L-L-Y, @asmp.org. And we also have a blog that's published every weekday. It's asmp.org/strictly business, which is the name of our ongoing business symposium that travels the country. And there's a lot of great tips. There's good professional information. You don't have to be a member to get that blog. But I do encourage you to consider joining if you're a photographer, you are an emerging photographer, you're considering photography as a career choice. It's nice to have a peer community. It's nice to have somebody to talk to that understands what you're doing. It's a lonely business, even in a city of 8 million people. And having somebody you can talk to is great. The chapter here, we have 39 chapters. The chapter in New York is our largest. And there's some great people that belong, some famous photographers as well as the people like me. I guess I'm pretty close to being done. I'm so glad to meet everybody here, and I can talk to you guys outside. Thanks.
For more information, please visit us online, give us a call, or stop by our New York City Superstore. You can also connect with us on the web.